a quorum is here, so so we're going to get going. We have a briefing from the Department of Labor on the foreclosure process overview, and Meredith Merchant and Amy Hennon are here to brief us. And the briefing is expected to go for an hour, but if it ends early, we still can only begin the public hearings at 2 o'clock because foolishly that's what we told the public. So fie on them, I say. But anyway, so let me just hand it over to you. I'm going to presume you're one of those two people whose names I mentioned.
I am indeed. Thank you, Chair Barve. Members of the committee, thank you for the opportunity to be here. My name is Amy Hennon. I am with the Office of the Commissioner of Financial Regulation. To my right is my colleague Meredith Merchant, who is our Director of Outreach and Education. I've only been with the Office of the Commissioner for a few months, but I have been I was a consumer finance attorney for more than 10 years prior to that, including representing homeowners facing foreclosure. And the office brought me on because of my background assisting folks that were facing these consumer financial issues. So I hope we're able to provide some important information for you all today. So we're going to talk about what OCFR does, who we regulate, particularly in foreclosure issues, the process, the required notices, as well as provide some regulatory updates that I hope will be helpful for you all. I'm also going to talk about foreclosure fraud and how this is tied to our consumer protection work, as well as how to direct constituents to submit a consumer complaint that's often helpful. So the Office of the Commissioner of Financial Regulation is Maryland's consumer protection agency. Our mission is to protect Marylanders through the operation of a modern financial regulatory system that promotes respect for consumers, safety and compliance, fair competition, responsible business innovation, and a strong state economy. We license, register, charter, and supervise through examinations and investigations at certain financial service providers and financial service activities in Maryland. There are approximately 21 chartered state banks, 7 credit unions, 4 trust companies, and roughly 26,000 non-depository institutions, including mortgage lenders, debt collectors, money transmitters, check cashers, credit reporting agencies in the state of Maryland. When it comes to foreclosure, we regulate and supervise mortgage lenders, servicers, and consumer debt collection agencies, as well as the state chartered banks and credit unions. We also maintain the foreclosure registration system, and we pursue cases against those who would defraud Maryland homeowners. Our Consumer Services Unit accepts complaints from consumers where they investigate with a goal towards resolving issues. Because these complaints are regarding businesses that we regulate, staff can obtain and review things like original loan documents and get to the source of the dispute. For FY22, we received over 1,100 complaints, and approximately 1/4 of those complaints related to mortgages. Complaints are used by both our licensing and enforcement units. When we discover an issue with a complaint, we can make sure that the issue gets corrected, and then we can seek restitution where appropriate. Additionally, OCFR takes action against licensed and unlicensed entities that violate Maryland laws. And so that could include, for instance, foreclosure rescue scams or things like that. In FY22, we ordered over $1.1 million in restitution payments to Maryland consumers, and our Consumer Services Unit specifically recovered an additional $121,000 for Maryland consumers. In addition to the slides, you all received our FY22 highlight fact sheet that lays out some additional accomplishments for the office for the last fiscal year. So on the screen, you can see the steps of the Maryland foreclosure process. There are a combination of state and federal laws that go into this. OCFR regulates a portion of some of these stages of the foreclosure process. Particularly, you'll notice the notice of intent to foreclose, the notice of foreclosure filing, as well as the foreclosure property registry, including the initial and final components. If we look at this another way, we've got our flow chart here. If we look at it another way, the chart shows how somebody would potentially move through this process. There are some important distinctions here that I want to call out about whether if a mortgage is federally related or also if it's owner occupied. These are things that really impact how the process moves. When I say if something is a mortgage is federally related, I mean that are we talking about an FHA, a USDA, a VA loan, and potentially also a loan that's backed by Fannie Mae or Freddie Mac? The first three, probably pretty obvious to the consumer. They applied for this loan. They know that they have that kind of loan. The consumer might not necessarily know if they have a loan that's backed by Fannie Mae or Freddie Mac, but the servicer knows, and there are also lookup tools on each of the websites to determine, is this loan a federally backed loan? I would say that approximately, or just under 40% of loans in Maryland are federally backed mortgages, though they do make up a larger share of normally minority purchased homes. So the 90-day versus 120-day, that is the difference between when the actual complaint can be filed with the court, is one of those important distinctions. 90 days if it's not federally related, 120 days if it is federally related. And that's the difference from the missed payment until the complaint can be filed with the court. But in between that time, there's also the notice of intent to foreclose, which is something that our office gets involved in. I'll also share that Maryland is what's called a quasi-judicial state, and that means that throughout the foreclosure, though the foreclosure must be confirmed by the court, a portion of this process does occur outside of the court process. And there's not generally a hearing for the homeowner unless they've specifically requested this, and it's often tied to whether or not the servicer or lender has violated of Maryland or federal law. A little bit of a compare and contrast in terms of when I say quasi-judicial. The 100% judicial process, that's about 21 states and DC, where the entire process is managed by the court, and then non-judicial, meaning that it's 100% outside of the court process, that's about 27 states. Only Maryland and Colorado are considered quasi-judicial. So the other thing that I mentioned was the importance of the distinction if the property is owner occupied or not. Homeowners are entitled to seek mediation, which is not something non-owner occupied properties are entitled to. And that can be either pre-file or post-file mediation. Pre-filing mediation is often triggered potentially at the notice of intent to foreclose stage. That's not obligatory, but is possible. On the other hand, the final loss mitigation, which is tied to the complaint, which is tied in with once it's been filed with the court, the final loss mitigation stage triggers that post-file mediation. This is a very important step in the process for homeowners. Once that final loss mitigation has been filed, the homeowner only has 25 days to file to get there to request mediation. There is a $50 fee. The court can waive that $50 fee. The mediation occurs is done by an administrative law judge and occurs at the Office of Administrative Hearings. The ALJ has a checklist and goes over the various retention and non-retention options that the homeowner potentially has. A representative of the lender or servicer, their counsel, the ALJ, the homeowner, and any counsel they might potentially have are all going to be present at this mediation, and it's an important stage for the homeowner because it's their only opportunity to get everybody in the room together. So to look a little bit further into this notice of intent to foreclose stage, because this is a really important part, especially for us, but it's also really important for the homeowner to know where they are in the process. So this must go out at least 45 days prior to that order to docket, that complaint being filed with the court. So it's an early warning stage for the homeowner to let them know your home is at risk. OCFR receives an electronic copy, and a mail notice goes out to all named parties on the mortgage. In FY22, OCFR published a new fact sheet for homeowners about their rights when facing mortgage default, and we mailed that to nearly 50,000 homeowners. We've mailed out nearly 50,000 resource packets directly to homeowners at risk of foreclosure. And if anyone is interested, I have a copy of the Notice of Intent to Foreclose letter that goes out to folks that is in English on the first side and Spanish on the back side. In addition, we have the fact sheet, mortgage late, don't wait, that also goes out to homeowners. So the Notice of Intent to Foreclose, this is data that we have that we publish on our website and on the Maryland Open Data Portal. You'll note that the period from May 2020 to June 2021, when our Notice of Intent to Foreclose system was closed and no foreclosures could be initiated. So you'll see that there's that whole section where the number is 0. Prior to COVID, in 2018 and 2019, our Notice of Intent to Foreclose numbers were approximately 70,000, a little under 70,000 per year. Those numbers were down substantially from the all-time high in FY12, which was approximately 178,000 NOIs, so more than double. We have seen, I think you can see that the numbers of NOIs have been increasing, and we're approaching pre-pandemic levels, and so we'll see what FY23 has in store. So the Notice of Foreclosure filing. This was an important update that the General Assembly enacted in 2017. It requires a notice to be submitted to OCFR within 7 days of that order to docket, that complaint filed with the court, to initiate the foreclosure. This is really important because it contains important property information, particularly if the property is vacant, and also good contact information for who to reach out to regarding the property. Access to this information is granted to local governments and state agencies so that they can monitor foreclosure activities in their jurisdictions, particularly in light of the impact that foreclosed properties can potentially have on a community. And within the local governments piece, we include fire and police departments. Often foreclosed properties properties that are vacant can be a place where additional fire or police resources are required, and so this is why it's really important for local governments to have access to this information. So the Foreclosed Property Registry, again, really important, is granted to local governments and state agencies so that they can again monitor foreclosure activities, and the information again contains important information about whether the property is known to be vacant, and also good contact information for who to reach out to. Although legislators are not generally considered local governments, if there are folks in your communities, in your local governments that you're working with that are interested in this information, this is absolutely worth sharing with them, and I would encourage you to do so. And access to this information can be obtained through our website. So this chart lays out the much higher number is the notice of foreclosure, so that order to docket, that initial foreclosure complaint filed with court stage, and the lower number that's contrasted with it is the foreclosed property registrations. And so the difference is obviously that not every order to docket is going to result in a final foreclosure on the property, though there was a period where it was a very close correlation. That was also, a lot of that is in the time period of the pandemic, and so you can see normally there is a greater difference between the order to docket stage and the final foreclosure stage. So some important regulatory updates that are going to be effective March 1st. The two that I think are most important include that the notice of intent to foreclose stage, that expires after 1 year. And this was something that I think became pretty apparent to us during the pandemic, that an old notice of intent to foreclose shouldn't be used to notify the homeowner that they are at risk of foreclosure, and so it now expires after 1 year. And then the other thing that gets added in is I talked before about the pre-file mediation and the post-file mediation. Pre-file mediation, post-file mediation always had the requirement for good faith and fair dealing by the lender and servicer. This just clarified that also, yes, it does apply to any pre-file mediation that might potentially occur. And so again, those updates are effective March 1st. So we've got a couple slides in here about foreclosure fraud, which is of particular interest to our office. The two statutes that our enforcement unit focuses on are MARS and PIFA. Now, this is an area of significant concern for OCFR because consumers that are experiencing foreclosure are already having a very difficult time, and folks that would prey upon these desperate folks are truly taking advantage of folks in a terrible situation.
Could I interrupt you for a second? Could you tell us what the acronyms MARS and FIFA again stand for?
Absolutely. MARS, Mortgage Assistance Relief Services Act, and PIFA, for Protecting Homeowners in Foreclosure Act. These two acts together do basically what I'm about to describe in terms of the protecting homeowners. Yes.
Thanks a lot.
Of course. It's something that we in fact explicitly warn homeowners about, and it's in our notice of intent to foreclose letter to watch out for these sorts of scams. The laws don't apply to Maryland barred attorneys, mortgage lenders, servicers, banks, credit unions, licensed real estate brokers or salespeople, and nonprofit organizations that counsel consumers in foreclosure. These are, in fact, designed to get at out-of-state attorneys or folks that would potentially be promising loan modifications that might not actually be possible. And those are indeed the most common kinds of violations that we see. On the previous slide, there was also a link to our website where if you're interested in learning about some of the kind of cases that we've pursued, they are listed there. All right, and so, one more please. Thank you. So consumer complaints. You may absolutely have a constituent who comes to you who has got a concern, particularly with their mortgage or with some other entity that we regulate. These complaints can be submitted online or via a paper form. And if you have a question about, or if you have a question about whether or not something falls under our jurisdiction, you can reach out to me directly, or there's also some other contact information on this slide. And so with that, the last slide has both of our contact information, and we're happy to take any questions.
Terrific. Any questions? We have Delegate Holmes.
Thank you, Mr. Chair, and thank you very much for the presentation. I want all of you to know that Meredith has been presenting to us for years and 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 years.
Amazing for how young looking she is.
Yes. One of the things I would like for you to expand upon, if you don't mind, in terms of the foreclosure process, when there appears to be a vacant house someplace, and if one of us gets a call in terms of is the house vacant and who's responsible for cutting the grass, etc. Explain to the committee, if you don't mind, how the members of this committee could figure out who is responsible and how we could initiate grass cutting or getting in touch with the servicer if that's provided, etc.
Yeah, so this is exactly what the Foreclosed Property Registry is designed for, is for local governments to be able to get access to exactly the information that you're talking about, particularly because of the issues that come up with vacant properties. And so if a member of a local government, if someone who works for a local government is interested in getting access to this information, it is available on our website. They would sign up for a login and they would be able to enter the address of the property and immediately know what is the contact information for this property, whether or not it's believed to be vacant by the lender or servicer.
And is that for the local government, or can we as
So generally, legislators are not considered local government, at least in terms of the definition of this, but we are it is quite expansive in terms of what is considered local government. And so that, again, does include police and fire because of the potential impact on those services.
If I could, another question. Now, you indicated that there are 2 states that are quasi-judicial, Maryland and Colorado, I think it is. What is the advantage to being quasi-judicial? And if only 2 out of 50 are quasi, what would it take for us to revise our process?
You know, I think that that's something that for if the legislature wants to consider whether or not they want a fully judicial or a fully non-judicial sort of process, I think that there are a lot of advantages to the system set up the way that it is, but then again, that may not be the case for everyone. And so I think that it would require a lot more looking into.
Okay, thank you, Mr. Chair.
Thank you, Mr. Chair. I would like to refer back to slide 6 of your presentation regarding the foreclosure process. I think that there's a very important part that you might want to add between 5 and 6. There is a 30-day period for filing exceptions. And I think citizens need to know about that.
That is certainly true. The exceptions process is one that absolutely can be utilized to say, wait, hang on a minute here. Again, because of the sort of that quasi-judicial process, there is a very limited number of options for consumers to insert themselves or homeowners to insert themselves into the foreclosure process. And the exception stage is one that it certainly can be utilized. I think that the most effective stage is certainly the mediation stage, but there are plenty of homeowners that don't take advantage of either of them. There are lots of homeowners that don't actually get involved in the foreclosure process at all.
So I just won a case right at that period. So I think we do a disservice if we don't mention that. Thank you.
Can overturn the foreclosure.
So I think it's a very important. Process right in the middle. It's pretty much your last chance.
Absolutely.
And to make sure we tell citizens about the exceptions process, I think is really important.
Certainly, that's certainly something we can add to this chart. I think that it's obviously not one that's governed by OCFR, but it is governed by it is managed by the court, but that's absolutely something we should include with the flow chart.
We can add that to our outreach.
I'd appreciate it. Thank you. And if I can,
Go
Mr.
ahead.
Chair, regarding the number of complaints, did you refer to where we could find those?
Those indeed are on our website. There's also some important information about, just in general, in the fact sheet, but our full FY22 annual report is on our website, and it breaks down the number of complaints and the different kinds of complaints that we received and how those got resolved.
Thank you.
You're welcome.
Before I recognize the next delegate, I just want to say, first of all, thank you for this chart. It is a simplified chart. I had my staff many years ago do a very comprehensive chart, which was substantially much more complex. And if memory serves me correctly, the foreclosure process can go past 400 days in some instances.
It can move quickly, or it can go past 400 days. Both are possible.
Right. Okay. Next, Delegate Davis, if you could push the button on your. There we go. Delegate Lehman.
Thank you, Mr. Chair. And first of all, thank you, Delegate Holmes, for asking your question about the quasi-judicial process, because I wondered the same thing and would like us to maybe get more information about what it would look like to switch to a completely judicial system is what interests me. But so having said that, I have had this question for many years since the beginning of the attempts to sort of overhaul the whole foreclosure process and provide more consumer protection. Do you have evidence, data that actually demonstrates that this longer timeline for notice and for the requirement for mediation is in the end providing any real protection for homeowners and avoiding foreclosure? Because my sense anecdotally is it really doesn't. It results still in way too high number of foreclosures. It just draws the process out. Can you prove or disprove that? Have you before, or can you with data that you possess?
So I don't think that we have any data that would either prove or disprove that.
Why not? I mean, that seems like an important question.
So certainly the length of the process is one that is governed by both federal and state law, and so there are a bunch of different components that go into it. The one caveat that I would say about the length of the process and the ability for homeowners to step in is that or where homeowners can engage with the process. I think that I think the most important thing would actually be more homeowners being engaged with the process to begin with, rather than thinking about the length of the process.
But it's one thing to engage, which is important, but it's another thing if our goal is to keep people in their homes. And if we're not doing that, I'm not saying that longer timeline for notice and the opportunity for mediation is not important. It certainly is. But if in the end that does not, help people stay in their homes, that's very concerning. Mm-hmm. So I'm going to ask you a little more directly. Can your agency or another in-state government, setting aside your point about that there are both federal and state guidelines, produce some kind of data that can prove or disprove whether this much lengthier process is actually helping more people stay in their homes?
I can absolutely look into that and follow up with you.
That would be very helpful. Then my next question goes back to the foreclosure fraud complaint system. How do people know how to report when they think they've been or have been actually scammed? How are they made aware that there's a reporting system? Where do they go? Is that well publicized enough, do you think?
So again, in our notice of intent to foreclose letter that goes out to all homeowners, all homeowners that are facing foreclosure, there is a call out about avoiding foreclosure scams and some additional resources that they can learn about that. Many homeowners that are victims of foreclosure rescue scams discover after they've paid money to somebody and have then not received the benefit that were promised to them. And it's at that point that they often begin looking for resources for where they might go to potentially seek to get that money back. And that is something that our office does get involved in.
Okay, thank you for that. And last quick question is, where can we find information about, if it's available, about where those cases have been pursued and prosecutions have resulted?
Absolutely. That information is available on our website. There's a link in one of the slides that takes you directly to the page that has to do with enforcement of foreclosure rescue scams.
Okay, thank you. Thank you, Mr. Chairman.
I'd like to follow up on one of the concepts that Delegate Lehman brought up, and it's this. Obviously, if a person can't pay their mortgage, then the foreclosure does have to go through. But what with this process, what would happen if, say, I lose my job and I'm not able to pay my mortgage, and this process begins, and 6, 7, 8 months later, I get another job, and suddenly now I'm in a position to pay my mortgage? What effect does this process have to help me or not help me in that situation? I realize that the process is complicated and perhaps there's not a clear-cut answer, but if you could just give the committee a feel for, in that sort of scenario, what might occur.
So it truly depends on how quickly the servicer or lender has filed the complaint, the order to docket, and initiated the process for the foreclosure. If you have gotten your and depending on where you have potentially gotten your new job, if you have gotten your new job and you're at the mediation stage, this might be a good opportunity to bring to the table some solutions that you have with how to get either current or consider a modification. Those are options that could potentially occur at that stage. If you've gotten your new job and in fact it's already at the stage of ratification, you are probably at that point, you're probably thinking about a Chapter 13 bankruptcy instead.
Well, let me ask this. I mean, in the mediation process, obviously you have the two parties, the lender and the borrower, who the agency is the mediator, correct? I'm trying to remember.
The
believe it or not.
administrative law judge from the Office of Administrative Hearings is the mediator.
I see. And I would presume that this process is cheaper than a full-up legal judicial process, right? Or would it be about the same? I don't know.
I don't know that I could say what would be cheaper.
Okay.
You mean for
All right,
the
well,
lender?
oh, go ahead.
Do you mean cheaper for the lender?
No, for the borrower.
Yeah, that's that's
Okay.
hard to say.
Okay, let me go to the next question, goes to Delegate Morgan.
Don't touch the button? Okay. Thank you for that interesting presentation. And I'm happy to see the number of foreclosures. You said, 110,000, now we're down to a range of 5 to 6.
The 5 to 6 notice of intent to foreclose is monthly.
Okay, I got that part. Is there a geographic distribution on that, or is it just statewide, or is there concentrations of this that you're aware of?
There absolutely is our geographic distributions, and all of that information is available on our website and on the Maryland Open Data Portal. That's a really important question. I'm glad you asked that.
Okay, thank you.
Can you give us a Cliff Notes version of what the geographic distribution looks like?
Baltimore City and Prince George's County are hotspots of foreclosure activity, and I assume that doesn't surprise anyone.
Okay, and I just wanted to.
Thank you.
I just wanted to have it said. Okay, next question goes to Delegate Terraza.
Thank you, Mr. Chairman. And just a comment on the highest rates of foreclosure. At some point, I'm trying to remember if it was 207-23 or 207-63 in my district, had one of the highest rates of foreclosure. So I don't know if that's still the case, but I just want to know it's also happening in Howard County. So I just wanted to follow up on a couple of things that you talked about. I think the chairman asked you about the 400 days, and you said, and your answer was, it can take up to 400 days or it can be a lot shorter. Can you talk about what is that range and what makes it, is it the mediation that makes it longer? Like what's making it, what brings it to 400 days and what doesn't?
So if we're talking about a non-federally related mortgage and it's not owner occupied, the protections and kind of various offshoots of the process don't necessarily exist. And again, one of the important components is how quickly you go from when the person has missed the payment until the bank is the servicer or lender files the order to docket. The minimum is the 90 days or 120 days, but can obviously be quite a bit longer. And that is something that is up to the servicer or lender to determine when they're interested in, or how potentially if they're pursuing loss mitigation options, they might or might not consider filing immediately.
So if they were to use the, I mean, I'm concerned about the length of the process also, if it's not, as Doug and Lehman said, be helpful, but if the lender decides to go as fast as possible, what's the range there? What's the...
Before you answer that, our staff actually did this analysis many years ago, and I will have it produced for you.
All right,
But
that's
but
great.
go ahead and go ahead and respond.
Yeah.
Hi. So the days that are indicated here are what's in state law, right? So the soonest that they can file the order to docket, if it's not federally related, would be 90 days after default. And then at least 28 days later would be when the final loss mitigation affidavit can be sent. This is a summary version, so there are some time frames that are missing here. I think that Delegate Holmes has a much more robust version, and it sounds like your committee staff has already done that analysis. There's a number of factors in addition to the servicer, the federal laws, there's also the engagement of the homeowner. If they are pursuing loan modification or loss mitigation, they need to submit a number of documents. And if those documents become stale, so if they're over 30 days old, then the homeowner will need to submit new documents. And then it all depends on how quickly the servicer processes those. And then when it comes to the very end, after the sale and ratification, because that is very court dependent, it really depends on the caseload of the court. I recall during the height of the crisis 10 years ago, when Amy and I were both working on these situations, some of the courts were taking months and months to ratify sales. If that gives you a picture of all the various factors that go into, and a homeowner can right up until the sale, if they get a miraculous new job or somehow come into enough money, they can pay off all of their arrears, whatever they owe, and make the loan current. So that's always an option throughout the whole process.
Okay, no, I appreciate that, and I look forward to seeing. It sounds like it's very complex. I didn't realize when I asked. Oh, I'd love to, well, that's talented. Wow. That shows a lot of talent there. Just another question about, you said that the ability for the homeowner to engage in the process is limited, and did you say there's no hearing? Or there's no participation in that hearing? I may have written this down wrong.
So this was tied to the discussion of the quasi-judicial process that exists in Maryland, that a foreclosure, when an order to docket is filed, when this complaint to foreclose is initiated, there is normally no hearing that is generated for the court. With a complaint that might be filed for any other kind of case, there might be a hearing that gets automatically generated as a result of any number of things. But there's not necessarily an answer stage. There's not necessarily like a hearing stage unless the homeowner files something indicating there's a reason to have a hearing.
Okay, thank you. And then finally, just really quickly on the foreclosure registry, can you say again when it is that they wind up in the foreclosure registry, like which number here, and then just speak a little to why the access to that information is limited? So you said, for example, we can't get it, but police and fire can, and what that, just speak a little bit to that.
So I've changed the slide. It's stage 3,
Okay.
5, and 7. Okay, so 3, within 7 days after the order to docket being filed, the party that's responsible for the foreclosure needs to submit a notice electronically through our office with the information that Amy described, like just a basic property address, who's the responsible party. And then at stage 5, within 30 days after the sale, so the foreclosures happened, the sales occurred, within 30 days after the sale, the party that purchases the property, which may or may not be the bank, it could also be, investors or people just, owner occupants, the party that purchases the property at the sale has to register their information. And that particular law, the one that happens after the sale, was established by the General Assembly, I believe in 2011 or 2012, and it's the statute that dictates who has access. And the statute says, municipal and county officials and state agencies. That is that, and then it applies to the same for the notice at the number 3 stage.
If I can just offer what I think might have been the reason why it was selected this way, was that there is obviously sensitive information about whether or not a property is vacant and whether or not a home is in foreclosure. And I think the legislature sought to limit who might get access to that.
Okay, thank you so much. Oh.
Yeah, the citations, if you want to look it up, are on the slide.
Okay, great. Thank you so much.
You're welcome.
did something.
Vice Chair has a question.
Thank you, Mr. Chairman. Are there any federal protections for borrowers when they have a federally backed loan that are going away with the end of the federal COVID emergency in a few months? Or did those protections already go away?
So there are a variety of federal protections, and certainly there are some CFPB regulatory actions, including Reg Z, that have not gone away. Those still exist. But there are some that I think have already expired.
That were COVID related?
That I believe were, yes, that were COVID related, yes.
Okay, thank you.
Thank you, Mr. Chairman. I am under the impression, right or wrong, that if you foreclose on my property, don't I have a period of time after that to get this property back?
I mean,
So there's that time period between the sale and the ratification that Delegate Lehman, I believe, was talking. Davis, yes, thank you. Was talking about. So after the sale, the homeowner can file some exceptions to the sale with the court, and then the court determines whether or not to overturn the sale. We'll have to look into, unless you know off the top of your head, whether or not, Maryland, it's like, are you thinking like a full right of redemption? Like we can?
Yes.
I do not believe so, but we can double check for you.
I'm sorry you didn't.
We can double check for you.
Okay. Appreciate that. Thank
Sure.
you.
Thank you, Mr. Chairman, for giving me a second chance here. So one question is, are there penalties for lenders that do not comply with notice requirements? And if so, what are they?
so I believe that there are not penalties in the statute, but that if a lender or servicer were not to comply, that would be something that would be a potential exception to the sale, or something where the homeowner could seek to have the sale overturned.
Do you track that at all? Does someone track that? Because I've heard I've heard that complaint by advocates who I met with actually during the interim that said there is, no real sort of checks and balances in terms of what lenders do and don't do to comply with the law.
When it comes to one of the notices that come under our regulatory authority, I'd encourage the advocate or the homeowner or any of your constituents, if they're having issues, to please submit a complaint to our office so that we can do an investigation. And we have a number of powers associated with that. We can impose civil fines and penalties, or escalate it up through the enforcement action process if that's appropriate.
So respectfully, I'm not asking whether you can, I'm asking whether you do. And I think homeowners are already under enough stress and duress that to put that on them to formally register complaints, it's not a bad thing, but to put that completely on them seems unfair. So are there fines actually assessed and, by the system, and where can they be, looked at? I mean, where would they show up publicly?
We do engage in enforcement actions against servicers. We do also have that information on our website. I can't recall off the top of my head right now. If you want
If you
more
could follow up
detail,
and send that link, that would be helpful.
Sure.
To where that is. And then my last question, and it might require follow-up offline, is can you distinguish between foreclosure sales and short sales? And where do short sales sort of show up if they've been kind of forced, if it's a forced situation? How are they reflected or are they not reflected in your data?
Yeah, do you want to take that? Or you want me to? Go ahead. Okay, so foreclosure sale is when the secured party auctions the property, right? It's gone through the process. The homeowner none of the loss mitigation options are available, or for whatever reason, the foreclosure sale has happened. The short sale is voluntary when the homeowner sells the property in order to prevent the foreclosure.
So, okay, so again, then, the short sales probably are not reflected in any way in terms of the number of homeowners who end up losing their home because of, for a variety of reasons, whether it's a predatory loan or a combination of that and a job loss. And it's not, because those are, you can call them voluntary, but often they're forced. It's a homeowner's effort to not completely lose his or her shirt, right?
Sure.
Or to ruin their credit rating or whatever. So is that not calculated anywhere in your numbers?
We do not have short sale data.
So the short sale is one of the options that is discussed with the homeowner, I believe, at the hearing before the administrative law, the mediation before the administrative law judge. It's listed on the sheet that the ALJ goes over with the homeowner of deed in lieu, short sale, those are non-retention options in addition to the retention options that include get current and get a modification, among others. So if the homeowner were to engage in the short sale, which is generally going to be the home being sold for less than what the loan is, that would be something that the only reflection in the data would be the difference between the order to docket stage of foreclosure registration and the foreclosed property registration. The short sale could conceivably have occurred in that difference that exists on the screen that you see in front of you, but that's not something that we track. No.
Thank you.
Thank you, Mr. Chair. As policymakers, it's important that we follow the data. So could you please elaborate on why we shouldn't be surprised that the highest foreclosure rates are in Prince George's and Baltimore City?
Perhaps I spoke too off the cuff.
Yeah, so the highest foreclosure numbers are in the more densely populated jurisdictions that tracks, right? So like the I-95 corridor, Baltimore County, somebody mentioned Howard County, Montgomery, around those areas. We've made available data at the zip code level for notices of intent to foreclose. And then for these two data points that you see on your screen, the notice of foreclosure and foreclosed property registration, we've made that data available at the county level as well. We are digging into it and looking at connections and whether or not anything else needs to be released.
If I can. So given that information, do you do a comparison based on population?
Yes.
We can find that?
I believe so. We have a internal data unit that does those analyses.
Is that on your webpage also?
We do not have that on our website. We have the raw data on our website.
Is there a way the committee could get that?
Shoot us an email.
Delegate Davis, I'll note that we should get you that information.
Thank you.
Any more questions before we conclude the briefing? There appear to be none, so thank you very much. Obviously, there's a lot of interest in the committee for a lot of this information. We appreciate you making this briefing to us, but I thought it was a good starting point, especially for the newer members of the committee. So we will be back at 2 p.m. for our public hearing because, as I said, we publish that to the public. So we'll start at 2 p.m., so that means another 14 minutes. So see you then.
Good afternoon, Bob.
How are you?